Good afternoon, everyone. My name is Jamie Schenker-Pissarro. I'm an Associate Director for Temple Small Business Development Center. We help small businesses start and grow. And these days we are doing that virtually through phone or Zoom consulting and through our virtual training like the one that we have today. I will post a link in the chat that includes our Google Doc that we are updating every day, and that includes resources for your business during COVID-19. It includes a list of our upcoming webinars that you can register for, and it also includes links to previous recordings of webinars that we've done so far. So I will link that in the box. Today, we are running a virtual training on a topic that was conceived pre-COVID-19. So we figured we would continue to offer that to you. We would just do it virtually. And this is a topic that our office hears a lot about, and it's a big topic. And this is about your employee manual, what to put in it. Where do you start? Do you do it on your own? Do you use a template? Do you work with a company? There are a lot of questions that we get about this topic, and we are really glad to have Bernard Williams with us today to talk to you about that topic. Bernard Williams Esquire is an entrepreneur, business leader, and attorney who has represented business owners for 18 years. In 2016, Bernard formed Company Counsel LLC. We'll make sure to get that contact info to you. After seeing too many small business owners struggle because they did not have access to quality legal advice and counsel when they needed it, today, as the managing partner of Company Counsel LLC, Bernard focuses his legal practice on helping small business owners beat the odds, make better decisions, and grow companies that impact the world. I'll post a link to their website now, and I will turn it over to Bernard. And for all of you joining us, we have you muted, but please feel free to put any questions either in the Q&A or the chat. I'll be monitoring that and directing that to Bernard as we go, just to make it more interactive. We both agree that we want this to be as conversational as the virtual format allows, so please feel free to ask any questions. And just try to make sure those questions are maybe more generally applicable, and we will get to them. Thanks, Bernard.
Thank you, Jamie. I appreciate the introduction and the opportunity to talk about this topic. You know, it's funny, I'm glad that you mentioned that. It was pre-COVID that we first sat down and talked about putting on this topic, and a lot's changed since then. This was going to be an in-person lunch and learn. I was looking forward to maybe getting a roast beef wrap or something, and interacting with a room full of people. And maybe more importantly, the things that I would have talked about then are a lot different from what I'm planning to talk about today. So, you know, whatever outline I had back in February, I've torn up and thrown out and started all over again. But I think this is as timely a topic as ever, even if the content itself has shifted quite a bit. So again, the topic is what to include in your employee manual. And an advisor of mine once told me that whatever you do, whatever you present, whenever you really do anything, that it's important to start with why. So that's where I'll start. Why are we talking about this? And I'll tell you from my perspective. You know, I've been practicing law for about 20 years now, and a lot of that was in the litigation setting. Litigation just means lawsuits. You know, either plaintiff side or defendant side. But typically, we've defended defendants, companies, in employment law settings. And you know, these are generally not bad people. These are generally not evil corporations. They're good people trying to run great companies, and they're just getting it wrong for whatever reason. Or maybe they haven't thought through certain things for whatever reason. Ideally, we'd like to come along and help them to put the right things in place proactively so that they don't run into any problems. But unfortunately, we don't always have that opportunity, and that's not always the way that we're introduced to people. So, you know, oftentimes we are introduced to them as litigators, and we're looking in hindsight. That's really what litigation is. You're looking backward to see what should have happened, and because whatever should have happened didn't happen, that's where we are now. So let's look backwards a little bit from the perspective of litigators. We're living in an age, and this is even pre-COVID-19, where employers are facing increasing risk, uncertainty, and pressure. If you look at the statistics, thousands of small businesses are involved in lawsuits every year, and it's not just the fact of their involvement; it's the amount of money that's spent once they're involved. You can see on the screen, at a minimum, $3,000 is the least anybody could ever spend once they're sued with a lawsuit in the employment sector. And that's very, very low. That $150,000 end of the range is oftentimes a lot more what you might expect depending on the complexity of the situation. Now, those are just the litigation fees that is independent of any amount that's actually paid in judgments or in settlement amounts. So maybe in part because of the amount of money that small businesses have to come up with to defend these lawsuits, the litigation survival rate is low. Of all the small companies that are involved in lawsuits, 85% of them go out of business within 2 years. If you're looking just in the employment context, because let's face it, a small business can be sued for a lot of different things, and maybe there's some topics for another day. But in the employment context, employment law issues make up about 30% of all civil litigation in the United States. And the average settlement amount in these cases is $40,000. So you can do the math yourself. If you're looking at averages, it's probably going to be between $43,000 and $200,000 to get out of an employment law dispute once it's been filed against a small business. Now, to make things even harder, the laws are changing all the time. New laws get made, old laws get reinterpreted. Old laws maybe come to the surface that weren't really enforced before. Things are happening, things are changing all the time. Even before COVID-19, the amount of statutes and regulations that are applicable to employers have quadrupled between 1980 and 2020. And that's just on the federal landscape. It's not even counting the local laws and the city and state laws. So getting back to my question, the question of why handbooks are important and why I want to talk about it is that handbooks proactively protect employers who want to do the right thing in the right way. Now, most small businesses are led by human beings. All the ones that I've ever encountered are. And a lot of human beings procrastinate. They focus on the things that are right in front of them. They put out the fires they have to put out. And anything that's not an immediate emergency, they'll put off for a later time. The problem is that's how a lot of small businesses and the management thereof treat legal issues. If there's not a lawsuit staring them in the face, they'll probably put off thinking about making changes to their legal structure, to their employment handbook, to their policies, they probably won't think about law very much at all. But then once you get sued with a summons and a complaint, then it becomes an emergency, and that's when they start to take it seriously. The problem is, as much as I can understand the human nature of procrastination, once you've been sued, it's too late to do anything preventative. The problem's already occurred. There's already a case against you, and it's just a matter of how much money it's going to take to get it resolved, how much time, and how much stress. And the previous slide, we talked about what that can look like. So what I want to hopefully persuade all of you of today is that the best time to think about these legal issues is not when you get a notice of discrimination, not when you get a claim from the EEOC, not when you get a notice of a lawsuit filed in court. The best time to think about these legal issues is long before these things ever actually come up. And long before you're dealing with another attorney on the other side.
Bernard, do you think this is a good time to maybe do a show of hands and see who actually has an employee manual in place now?
I would love to see that, yes.
Okay, so you can do a raise hand. Yep, some of you are doing that. Okay, great. So I know 2, 3, 4. Okay.
Excellent.
5. That's good. That's good. I'm glad you guys are all thinking about that and you were aware that preparation is the key. It looks like we have about maybe half of the folks. Thank you.
Okay, that's terrific. I'm glad to hear that, because in all the cases that I litigated involving employment discrimination, one of the questions that always comes up is, was there a handbook? And I was always, well, it was always a much bigger challenge when I had to say, no, there was not a handbook, because that meant that there were certain things that should have been in place that we could not prove were in place. So those of you that already have a handbook, you are on the right track. And those of you that don't have a handbook yet, you're also on the right track because you're here.
We have some who haven't updated in a few years. That we have some who mentioned that.
Okay, and that's fine. You know, these things are changing. Well, let me back up. Everybody that's within the range of my voice is, I think, where they're supposed to be. Whether they just updated their handbook yesterday, or whether they never had a handbook, or have had one that haven't updated in a while. Hopefully, we'll talk about some things that will either convince you that you're doing things right and that you're on the right track, or if you hear something that makes you think, well, I hadn't considered that, then this would be a good opportunity for you to make those updates. So wherever you are along the process, I think you're in the right place. So let's talk for a second about what the handbooks actually provide. So we said that they're evidence to protect the employer against discrimination and unfair treatment, right? But it's more than just that. It's guidance and information about the history, mission, values, vision of the company. Those are things that make the company special, the things that make employees want to work there. And that should be in the handbook as well, in addition to the legal stuff. Summary of the policies and practices, the expectations of management. This is, for a lot of companies, the only written source of communication between management and employees, where management tells the employees what they expect and what they can, and what those employees can expect of management. So let's get into some of the actual topics. These are the topics that, in my view, should always be included in an employment handbook. A statement of commitment to diversity and inclusion. Policies detailing procedures for employment discipline. Policies on confidentiality and whistleblowers. An employment at will policy. Drug testing policies. Anti-harassment policies. Discussions of leave and time off. Social media. Attendance. Hours and benefits. Now, these are the things that, as I said, should always be in a handbook, but the way that you approach some of these things may be a little bit different depending on the situation.
This is a great overview, by the way. Like, very, very helpful to see it laid out like that. So thank you. Okay, great. So let's linger here for a moment then. So the statement of commitment to diversity and inclusion. The importance of that is that that's the starting point for addressing discrimination claims. So if the company can't say that they stand for diversity and inclusion and against discrimination, then they're not going to have a very good chance of defeating a discrimination claim. The policies detailing employee discipline. The fact pattern that usually comes up in these cases is that someone will be treated adversely, meaning they'll be either terminated or demoted or some other kind of adverse employment action that they will feel was unjustified. Maybe they'll say, maybe they'll be fined or demoted for coming into work too late. And they'll say, well, sure, I may have come into work too late on this day, but you shouldn't have treated me this way as a result. And when so-and-so did the same thing last week, she was treated differently. He was treated differently. Because I'm being treated differently in the way that you discipline me,
that's given rise to my belief and my right to file a claim against. So making sure they have consistent policies with respect to employee discipline that are specific enough so that people know generally what to expect, but have enough wiggle room so that when things come up that surprise you, you can address them without going through a formalistic system. So in other words, there are a lot of employee handbooks that will have what's called progressive disciplinary measures, where they'll say that for the first infraction it's a verbal warning, for the second infraction it's a written warning, for the third it could be suspension, and for the fourth is termination. Well, if somebody does something so egregious that they've never done before, sometimes people can do things that are so egregious that it doesn't matter whether or not they've had warnings. The first time they do it, it merits termination. Things like violence in the workplace, you don't want to have to wait until the fourth time to terminate somebody who's demonstrated violence in the workplace. That should be done right away. So the point is that you want to have the ability for progressive discipline, but the wiggle room as management to be able to make decisive actions in cases that maybe you hadn't anticipated when you originally wrote the handbook. Let's go to the next slide and talk a little bit more about discrimination. What's there? And okay, so the discrimination cases tend to be brought under one of three different claims, or three different bodies of law, I should say. Either Title VII, which, and usually there's going to be claims of sex discrimination or racial discrimination. The ADA will involve claims of disability discrimination, and the ADEA will involve claims of age discrimination, which generally pertains to people who are 40 and over in the workplace. If someone is in any of those protected classes, a protected sex class, protected race class, disability, or age, and they've experienced an adverse employment action, then they have the right to bring a claim, a discrimination claim against that employer. Now, what do they normally do? Right. The way that normally looks is that they'll say that the reason that they were given by their employer for whatever adverse action they experience isn't believable. It's absurd, or it's not consistent, or the employer broke from the norm, or treats other people differently, or maybe it looks like the employer tried to make something up after the fact and paper up things that didn't actually exist at the time. Ultimately, whether a claim is brought from the EEOC or whether it's in a civil litigation setting, what all the parties involved are thinking about is, what is a jury going to say? What's a regular human being going to say when everything is laid out in front of them and the employee tells a story and the employer tells a story? Whose version makes sense? And if the employer doesn't have a version that makes them look fair and that can prove they've always treated that employee and every other employee fairly because it's important to them and it's documented and it's just part of their DNA, then the employee is likely to prevail. So in addition to I guess kind of the things we've known since 1964, right? So just going back quickly, we've known since 1964 that the sex discrimination was potentially could give rise to a claim. We've known that racial discrimination could give rise to a claim. We've known about disability. We've known about age. What's new is that, in fact, as of less than a month old, less than a month ago, the U.S. Supreme Court just ruled that the Civil Rights Act protects gay, lesbian, and transgender employees from discrimination based on sex. Jamie, I see you applauding. If anybody else wants to applaud, you should feel free to.
Hey, I went to law school a long time ago, and I remember being so frustrated in my employment law class and just realizing that this was not a protected class yet, and it took a while, but I'm glad that we got there and recognized discrimination in this way and how real it is and how important it is to have these protections.
I couldn't agree more, and it's further evidence that what's amazing to me is that it was actually the 1964 Civil Rights Act that was interpreted in 2020 to provide rights as of 2020. And as you said, everybody knows from law school that these were not protected classes. So for the Supreme Court to interpret such an ancient law to provide new rights, arguably new rights, or at least to confer new rights, is pretty groundbreaking. It's pretty historic. And what it means is that anyone who understood the way the law worked with respect to the EEO prior to June 14th, 2020, needs to update their thinking because there are things that would not have given rise to meritorious discrimination claims on June 14th that will give rise to meritorious discrimination claims now. So it's important that your handbook, when you're talking about your EEO policy and your commitment to diversity and equity and inclusion, that it encapsulates not just the stuff we've known for a long time, but also the things that have changed and incorporating this Supreme Court decision from last month. Just show of hands, out of curiosity, was everybody aware of this Supreme Court ruling? Was anyone aware of it?
Seeing one, two.
A couple people? Okay. So
a few, and some people saying no.
Okay.
I mean, there's a lot of news to overshadow it, but this was a bit of good news, and in my opinion.
Yeah, and I share that opinion. I thought this definitely was good news. And if anybody who wants to,
someone said it was so monumental. Yes, I agree.
And if anybody wants to read further, it's Bostock v. Clayton County, Georgia. And I don't have the whole case here. I just have the visuals so that you see what the actual front page of the opinion looked like. But you could just do a Google search for Bostock v. Clayton County. Bostock was one of the names of the plaintiffs who originally filed suit. There were 3 plaintiffs, all of whom were discriminated against in their workplace because they were gay or transgender, filed a suit on that basis, and ultimately this is how the case was decided. So now the way that this relates back to employment handbooks is that, as we said from the outset, the laws are changing all the time, and not only are there new laws being implemented, but old laws are being reinterpreted to confer new rights and new responsibilities from the perspective of the employer. So it's important that the handbook keep up. Now, we talked about how the employees can file discrimination cases. What are some of the things that employers, that management can do in the handbook as evidence against the discrimination? Well, this is one that I've said a couple times already. You can say that discrimination is illegal and that it won't be tolerated. You can say that you will provide reasonable accommodations for anybody who needs them for medical and religious reasons. You can provide mechanisms for people in your company to report problems that they see, either because they're personally experiencing discrimination of some sort or harassment of some sort, or because they've seen it experienced towards someone else. You can make it clear that anybody who participates in such an investigation would not be penalized for participating, and that there is an element of confidentiality to protect people who report discriminatory content. You can make sure that you're protecting people and that you're saying that you're protecting people against retaliation in the handbook. You can do as much as you can put in writing that it's important to give the employees the procedures to follow, and give them the assurance that if those procedures are followed, they'll be taken seriously, that they'll be treated fairly, and that they won't have to worry about retaliatory or adverse consequences for standing up for themselves or others. So, so those are some of the things that have changed in the EEO world, in the discrimination world. But the reality is that changes are happening all over the place. I never would have thought when I was in law school that medical marijuana would be as prevalent as it is now. And granted, I went to law school a really, really long time ago, but it's not something that I still go with. Marijuana still is illegal under federal law, but depending on the states, it's recreational, or I'm sorry, I should say, adult use marijuana is available in some states, medical marijuana in others. Pennsylvania is a state where medical marijuana is permitted under state law. And that changes a lot of the assumptions that employers have always made about drugs and drug testing in the workplace. So what is an employer supposed to do if he's got or she's got an employee who has a physician recommended prescription for medical marijuana, who shows up to work high, or what happens if maybe they don't show up to work high, but they go home and they use medical marijuana. Those things are all treated differently now than they would have been before. So to be clear, it's never appropriate to be high, to be intoxicated, to be under the influence of any kind of drugs or alcohol while at the office. But the drug testing policies have to be a little bit different than what some employers were doing previously, because somebody can now test positive for having marijuana in their system, even though they're not high. And if they have a valid medical reason and a prescription, then that can't be held against them under the ADA. Does that make sense? Any questions about that? Okay. One of the other things that's changed recently, and this has been more of a gradual change as opposed to something that was that came about as a court order, but gradually over the years, people have been using more and more social media. And sometimes it's recreationally. People are on Facebook while they're at work. Sometimes it's in a professional capacity. People can use LinkedIn or other forms of social media to do legitimate business functions while they're at work. Workers should be aware that employers generally have the right to monitor their workers' use of the internet, email, and social media. So the employee manuals should have statements that employees do not have an expectation of privacy when using social media at work or on work devices. So that's one of the things that needs to be put in a handbook now that people weren't really thinking about a few years ago because it wasn't nearly as prevalent. And although the approach of this has grown gradually over the years, there was a recent ruling from 2018 from the Pennsylvania Supreme Court that makes it even more important to pay attention to this. Based on this ruling, employers are legally responsible for protecting their workers' sensitive information. So in other words, if I'm an employee and I have my medical records and maybe my home address, or maybe my other personally identifying information on a work system, and my employer gets hacked, and my personal identifiable information goes out into the ether, I have the right to sue my employer, my company, for negligence and for financial damages. So so that means that the employers have a heightened responsibility both to safeguard their workers' information and to make clear that they don't have a general expectation of privacy when they're using social media at work or on their devices to protect them from that potential liability. Any questions about that?
Yeah, okay, so a question on that topic. Are there resources or policies on how to protect yourself as an employer if employees speak about company matters on social media while also taking into account freedom of speech?
Yes. So freedom of speech it's a federal right, but it doesn't mean it's a First Amendment right. But it doesn't mean that you can say anything at any time, anywhere, of any content. There still are reasonable limitations that can be put in place, particularly from private employees. I mean, I'm sure if you've been watching the news, you've seen examples of people in the news media, people who represent companies, employees who have been terminated for the things they say on social media. Whether it's an expression of a belief, controversial or not, or whether it's something defamatory, whether it's something that breaks confidentiality. Yes, adverse actions can be taken against employees who, based on what they say in social media. That doesn't interfere with their. It's just not really a First Amendment right question. To the point of employee handbooks, one of the things you can do in the employee handbooks is to talk about the kind of conduct that you expect. So if you anticipate that it may be a problem, then you can put you can describe the kind of conduct that's not acceptable by the company standards, and include certain disclosures or certain types of statements on social media to make it clear up front that if an employee were to engage in that kind of conduct, that those are things that they'd be subject to discipline for. Does that answer the question?
Yeah, so I think there are a few situations. Obviously, if confidentiality is breached, that's pretty obvious. If they are, the other side of it, you can proactively talk about policies with your employees as representatives of the companies to prevent things from, to kind of let them know that certain public statements, even on their own personal account, would reflect poorly on the company. So we have seen lately people saying racist comments and then they're getting fired from their jobs. And that, so I guess maybe can you tie that into how that would, how your employee manual can offer that protection and say, yeah, that is your personal views, but that reflects poorly on the company, and that's not part of, that's not what we uphold as our values in our employees.
Yeah, and that's exactly how you do it. So you'd have typically most handbooks have either an EEO statement or a statement of values, or a statement of values at the very beginning of the handbook. And that's where they'll talk about commitment to diversity, commitment to equity and inclusion, intolerance for discrimination that's illegal. So that's where you set the stage. Then at various points throughout the rest of the handbook, you refer back to that, and you need to talk about the specific policies and conducts that are acceptable to you and that are not. So for example, treatment of employees is often treatment of coworkers, I should say, is often included in the handbook, because the way that workers treat one another has an impact on the company and on the workforce, and can give rise to discipline. So while there may not be a law that says that you can't be a jerk to a coworker, if the company has expectations with respect to conduct that you treat people in a certain way, then they can and should say so in the handbook, and maybe give examples about what's okay and what's not okay. And well, giving examples about what's not okay probably is better. But something like that should be called out in the handbook. Treatment of clients, treatment of coworkers, statements made on personal email and personal social media, things that people might not think impact their ability to do the job, but that reflect on the company poorly, and that and that give rise to disciplinary action.
It seems like that is a place where having that policy in your employee manual is just so crucial, because then you could say, look, it's not about this, that, or the other thing. These are our policies. And then you can just protect yourself. It seems like that's so important to have that in there.
Right, especially, and this is why we started out by talking about the litigation. If someone were to be terminated for what they say in social media, and the handbook is silent on employee conduct and on statements made in personal social media, then it's a lot harder for the employer to defend the decision to discipline. If they can say, you know, it's always been in the handbook.
You knew this when you signed up for this job.
Exactly. Then it's much more defense. Then closely related to the social media is cybersecurity. And this is much more prevalent now than it was 3 months ago, because a lot more people are working remotely than ever in the history of work. I'm working out of my home office as we speak. A lot of people are using their own devices, whether it's a smartphone or a laptop, and they're doing things on those devices that might be completely benign, but that expose anybody on their network to hacks and to viruses and to other problems with regard to cybersecurity risk. Almost every company is vulnerable in some level or another to cybersecurity hacks, and an innocent click of an email link can lead to big problems. So it's very important for companies to specify in the handbook what actions workers should take to minimize their risks so that they don't bring down the entire network. And this is less about protecting the employer from lawsuits and more about protecting the company from shutting down. If a hacker gets into your system, there are ways that they could delete all the data for anybody else on your team. They could wreak a lot of havoc that could put that business literally out of operation for days, weeks, or even permanently. So in order to protect the company from that kind of catastrophic event, it's very important to make clear to all staff what actions should be taken to minimize cybersecurity risk. All right, so now let's get to the elephant in the room, COVID-19, and as a lot has changed in the past few months. We talked about the Supreme Court ruling. We talked about some of the other changes in the law, but probably the single biggest change to our culture and to our world and to our workplaces are related to COVID-19. It's changing the way that we work. It's changing when we work. It's changing where we work, and for a lot of us, we've been making things up as we go along, and adapting as we learn more and as the situation changes. it's always important to keep your handbook updated. But in view of COVID-19, it's more important than ever because there have been new laws that have been enacted specifically to address COVID-19. And in addition to the new laws, there are other implications of old laws that we never had to think about before. So the suggestion is to either to review the entire handbook, to revise the whole handbook, which again, it should be revised and updated regularly anyway. Or if you've recently updated the handbook, maybe in February, maybe instead of updating the entire thing, you just prepare an addendum addressing the things that are different during the pandemic. So over the next few slides and over the next few minutes, I'd like to focus a little bit on how to change the employee handbook to address employee safety, remote work, and changes in hours and potential layoffs. So first, safety in the workplace. Safety first, right? For a lot of, well, some companies are back in operation and people are back at work and they're back in the office or in the shop, and it's important to maintain personal preventative measures while they're in the office or the workplace, wherever the workplace is. One of the things that we've all heard by now that's important to do is to wash our hands. Because washing hands has always been important, but it's taken on heightened importance now because if we don't wash our own hands, then we potentially could expose our coworkers, our customers and clients, and it can make our entire workplace a dangerous environment. So some of the things that you should think about and you should address in your either your updated handbook or in your addendum is if you want your employees to wash hands immediately upon work, tell them that in the handbook. If there are certain periods where you want employees to wash their hands, maybe every 15 minutes, every hour, whatever it is, then make sure you say that in the handbook. And this is going to depend on what type of workplace you have. If you're in an office environment, maybe it's not that important to wash your hands as often as it would be as opposed to a medical environment or a food service environment. If you're in environments where you're handling things other people are going to be touching, then hand washing more frequently becomes that much more important. So however important it is and however frequent you need for the hand washing to be in your workplace, make sure you say that in the new addendum or in the updated version of your handbook. Similarly, workspace disinfection. If you're in an environment where a lot of people are using the same workspace, or where you're interacting with a lot of different people, maybe over time through that workspace, it's that much more important to keep the workspace sanitized. Talking to your employment manual about what that actually means. How often should the employees be cleaning and sanitizing? What kind of materials should they use? What techniques should they use? Who's responsible for what? And what is the business going to provide and what is the business going to do versus what individual employees have to do and what are their responsibilities? A lot of this, again, will depend on the type of workplace that you're in. But these are some of the things that you're going to want to think through and address in your handbook. Employee temperatures. Some people swear by them. Other people think that they are all for show and they don't do anything. But either way, as management, you need to make a decision. If you decide that it's important to check employee temperatures before the employee enters the workspace, then you should say so. You should say that you're going to do that in your employee handbook. You should dictate when those checks will occur, what the procedures are for people who demonstrate a fever, what happens if somebody develops other symptoms while they're at work, and what the procedures are for anybody who doesn't quote unquote pass a temperature check on the way through the doors. If you are not going to have temperature checks, then you might want to say that in the employee handbook also, so that you're not including, or rather, so that you're not creating an expectation that people will be checked when they enter the facility. Shared foods. So one of the things that I used to like about the office environment were the Friday morning breakfasts. I tend not to eat breakfast during the week, but every Friday my office would have this great spread with bagels and coffee and juice and fruit. It was great. So I would pick out and breakfast on Friday mornings. That's probably not going to be happening anytime soon. So particularly if you're in an environment that used to have lunches, that used to have shared meals, that would have people congregate in the break room for meals or lunches. Establish in your handbook that you just can't have that kind of communal experience during the pandemic. Talk about what the procedures are for the cafeteria. Talk about how employees can eat lunch at work if they need to in safe and compliant ways. And if there are particular areas in your office or in your work environment where no food should be brought in, then make sure you're clear about that in the handbook. Social distancing. The best practice is that people should be about 6 feet away in either direction from any other human being. In some workspaces, it's easier to do than others. So if you live in a place, or if you work in a place where you have your own office and you don't interact with anybody else in your office, then that's one thing. If you work on an assembly line, for example, that's something different. If you tend to work in groups or in teams, in physical locations, then your company is probably gonna have to make some changes that address those situations, because the whole team can no longer share the same tight physical spaces that they used to be able to. You no longer can cramp 10 people into a small conference room. So discuss in your handbook what the rules are for in-person meetings, how many people can be in a room, and what the expectations are for video and remote conferencing as an alternative. Staggering breaks. So this is kind of a combination of the last 2 points. Because you're maintaining the social distance and because you are discouraging people from eating together, it's a good idea in environments where people are given breaks to stagger those breaks so that not everybody is on break at the same time. That probably is going to take some maneuvering based on how many people are working in your environment and when the break schedule normally is. And of course, you're going to have to be compliant with labor laws and any union or collective bargaining agreements. But to the extent possible, change around your break schedule so that people can be socially distanced from others and feel safe. And establish expectations for what employees do when they come back from break. So, for example, if they leave the office for lunch and they come back, then and you're at a place that does temperature checks, then maybe they need to do another temperature check. Maybe they need to wash their hands again, etc. But whatever you decide and whatever makes the most sense for your workspace, make sure that you address that in your employment handbook. So some of the other changes that have been brought on by COVID-19 have to do with medical leave. The FMLA, or the Family Medical Leave Act, has been around for a while, and up until recently, it was pretty easy to understand. And in fact, for most small businesses, that were considered small, i.e. those that had 50 or fewer employees, they didn't have to worry about it at all. It didn't apply to them. It was only when an employer had more than 50 employees and certain eligibility requirements were met that those employees would be required to give 12 weeks of unpaid job protected leave. And there were certain guidelines to follow, and all that was important, but it was pretty easy to understand. And again, it didn't apply to smaller companies. Well, as a result of COVID-19, Congress passed the Families First Coronavirus Response Act, the FFCRA. And what the FFCRA did was that it dramatically expanded the FMLA. So now, if you have fewer than 500 employees, that's fewer than 500 employees, up to 499 employees, then your company must comply with the new paid sick leave expansion rules. Now, if you have fewer than 50, and you can say that the expansion would threaten, that the expansion of the Sick Leave Act would threaten the viability of your business, then you can apply for a small business exception. But if you're between 50 and 499, or if you're between 1 and 50, and you can't say that the new sick leave would threaten the actual viability of your business, then you are going to have to apply with the FFCRA, and these new sick leave rules will apply to you. So here are the responsibilities if they apply to your company. Employers will have to now provide up to 2 weeks for full-time workers or the equivalent in part-time employees in sick time at their regular rate of pay. If they can establish any of these things, they are subject to a local quarantine order. They've been advised by a healthcare provider to stay home because of COVID-19. They have any COVID-19 symptoms. And I'm sorry, there should have been, those are the 3 reasons, I'm sorry. If they're subject to a quarantine or isolation order, they've been advised by a healthcare provider, or they've experienced any COVID-19 symptoms. They can also get 80 hours of paid sick leave at 2/3 of their rate if they're caring for somebody in their household who is under a quarantine order or needs to self-quarantine, or if they are experiencing anything similar as specified by the Department of Health and Human Services. Additionally, the FFCRA also creates 12 weeks of paid sick leave, as well as expanded FMLA leave at 2/3 the employer's regular rate if they're caring for a child whose school or place of care is closed or is unavailable due to COVID-19 related reasons. Now, I've read through all of this pretty quickly, and I didn't want to really dive too deeply into any of these reasons or exceptions, because the overarching feeling that I've gotten in talking to people over the past couple of months is that almost everybody can say that they are either required to stay home because they feel symptoms, or because they know someone that has symptoms, or because they have a child, or because they're caring for somebody else, or because they have a child whose school has been closed. So it's very rare at this point that someone would not be able to meet one of those criteria. So if someone can meet one of those criteria and their employer is between 50 and 499 employees, then again, the expansion of the Sick Leave Act will apply, and it should be discussed in the Employment Handbook as follows. You should address how much paid leave they're entitled to, what are the procedures for applying for and approving of paid leave, what are the communications for check-in during paid leave, and what are the procedures for returning to work at the end of that paid leave. Now, in addition to the FMLA being changed by the FFCRA, the FLSA, it's alphabet soup, also is viewed a little bit differently now than it was before. The FLSA stands for the Fair Labor Standards Act, and although there have been no changes to the FLSA recently, the prevalence of remote work and people working from home, and the reductions in hours, the layoffs and the furloughs that have all occurred arising out of the pandemic, all have Fair Labor Standards Act implications. So most handbooks already cover the difference between an exempt employee and a non-exempt employee. The basic difference is this: an exempt employee is paid a salary, whereas non-exempt employees paid by the hour. For non-exempt employees, there's been a rise in recent history of wage and hour lawsuits where the non-exempt employee alleges that they have not been paid all the time they've actually worked, or they've not received all the breaks they're entitled to receive based on the FLSA. Now, because of telecommuting and the work from home policy, it's harder than it used to be, or at least it's different than it used to be, to keep track of and to know how many hours people are working from home and when they're taking breaks. But just because people are working from home, just because they're telecommuting, doesn't mean that the FLSA doesn't apply. So your handbook should describe what your telecommuting program looks like, what the expectations are for working from home, attendance, time logging, and overtime expectations, and the procedures for reporting expenses, reimbursements, and staying in touch with the office. The reason that you want to make all these things clear is that you don't want anyone to be able to come back and say that they were forced to work more at home than they used to be, or that maybe just because they're getting an email at midnight, now they're working at midnight, whereas before they used to have a 9-to-5 job. Eliminate any reason that somebody would have to say that their wage and hour laws have been violated as a result of the work from home requirements by making very clear what the requirements are, what the procedures are, and what your expectations are with respect to telecommuting and work from home right there in your handbook. Here it is again. Make sure that people know. Oh, okay, I'm sorry. For hour reductions, one of the things that a lot of employers did during the pandemic, particularly early on, was reduce hours. The FFCRA does apply if hours are reduced. And we talked about that a few minutes ago. You have the slides. You can take a look at that in more detail. The important thing here is just to point out that if hours are being reduced, if you think that you may have to reduce hours, then be sure to include in your handbook the employee's rights during this time period where their hours are being reduced. Discuss the continuity of employee benefits, like health insurance and dental and life insurance, and the procedures for communicating with employees about their hour reductions and about when they can expect to return to a full-time schedule. Furloughs and temporary layoffs. A furlough basically is a temporary layoff. And again, some employees weren't able to just reduce hours. They had to completely furlough employees or lay them off. But the same principles apply here for the handbook. You want to discuss in your handbook what the timeline is for reevaluation, what their eligibility is for employee benefits while they're furloughed or laid off, what the communication platforms are to stay in touch with furloughed or layoff employees, and what the reinstatement procedures will be at the end of the furlough. Any questions?
Yeah, Bernard. Question if FMLA applies to employees who have children whose schools transition to online. So there's not necessarily like a medical issue within the family.
Yes. Yep. So I'll go back. Yes. So there at the bottom, it's 12 weeks of paid sick leave and expanded FMLA leave at 2/3 the employee's regular rate. If they're caring for a child whose school it says closed, but it also means meaning online.
It includes online.
Right.
Oh, okay.
Okay.
Wow. Thank you.
Yep. Any other questions before we move on to the now what?
No.
Okay, then let's move on to the now what. So we have this handbook. What do we do with it? Well, you want your handbook to be accessible. You want it to be read. You don't want it to just sit on a shelf. So you want to establish a method for making sure that everybody within your workplace receives the copy, hopefully reads the copy, and acknowledges that they've done so. Best practice is that write an orientation for new employees, that you give them the handbook, and you also give them a written acknowledgement form that they've received the handbook and that they've had the opportunity to read it, review it, and ask any questions about it. There's some workplaces that use an intranet, so feel free to make the employment, I should say, if you do use an intranet, it's a good idea to make the employee manual available as a part of the intranet, but also make physical copies available. Eliminate any excuse that somebody could say that, yeah, I think we might have had a handbook. I saw that a few years ago, but I haven't seen it since. Or I don't have access to a handbook or anything like that. Make sure that it's visible, refer to it often, and every time there's an update, make sure you redistribute the handbook and get a new acknowledgement that the employee is aware of the updates and that they have had an opportunity again to review the handbook and the policies and ask any questions that you have. That the employee has. The other thing that I'll say is I think there are two people. There are two types of people that should be involved in the development of a handbook. One person is somebody from HR or somebody from management who really understands the culture of the company and can really talk about the vision and about the values and about those kinds of things that make that company workplace unique and special. And then there's your legal counsel. We lawyers aren't always so good about touchy-feely, and we're not always so good about, well, what I'll say is we're good at the legal stuff. We're good at making sure that your manual is compliant and that it addresses all the things legally that have to be addressed. And those really are two different skill sets. So if a lawyer has written the first version of your manual, make sure somebody from management or HR reads through it to make sure that the manual fits your vision, your culture, and your values. If the initial draft person is somebody from HR or management, then make sure that you give it to legal counsel to make sure that it's compliant and it doesn't go too far, and then it goes far enough from a legal perspective. Any questions about any of this? So just to wrap up, the documentation of company employee, documentation of your policies in a handbook is just the best defense you can have against discrimination claims and against most types of claims that would arise in the workplace setting. Employees are at will, which means that they can be in Pennsylvania. If they don't have a contract, they can be terminated. They can be they can have their hour reduced. They can lots of adverse things can happen to them unless they've been discriminated against, and that's when the law is implicated, and that's where companies get into trouble. So make sure that your employment handbook addresses those anti-discrimination laws and provides a defense to the employer should there be a claim of discrimination that's brought against them. At the same time, be careful to say in your employment handbook that nothing in that handbook changes the at-will nature of the employment status. So in other words, just because the handbook says it defines what the employment policies are, and just because some of the language is going to sound pretty legal in nature, that does not convert the employee from an at-will employee into a contracted employee. It's going to be very important for you to say that so that you don't inadvertently create additional legal risks the company would have to deal with. Remember that all the laws change frequently, and that it's imperative to review and update your employee handbook regularly. Make sure that somebody who understands the values of your company is involved in drafting the handbook and entry revisions, and make sure that legal counsel is involved to make sure that everything is compliant and legally sufficient. Once your handbook is written or updated, make sure that it's accessible to all staff. Give it to new hires in orientation, and be sure to document the employee's acknowledgement of receipt of the handbook. I think I see a hand raised. Is there another question?
So I have some questions from the attendees, but since we are past the 1 hour mark, I just want to let everyone know the content of our presentation has concluded for the day. So if you need to log off, you can certainly do that. I put in the chat box a 4-question survey that we are required by our funders, the SBA, to have you complete. So please do that. We'll send a follow-up email as well, but if you need to log off, you may do that. So we have questions about if we could maybe get a general sense of pricing to help a business put together an employee manual. There was a question about the SBDC and our services. So we do not write employee manuals for you. That's not something that is in the purview of a consulting relationship. So any thoughts, Bernard, about in general, maybe in Pennsylvania locally, greater Philadelphia metropolitan area, how that would look like if somebody wanted to get help with writing their manual, maybe some cost.
Sure. So let's start with the DIY approach. For anyone who wants to start out with something on their own, the place that I'd recommend starting is the SHRM website. SHRM is SHRM. And I don't remember what that stands for, but it's the go-to website for human resource materials. And that's what a lot of HR professionals use. That's what a lot of legal professionals use in the employment law context.
Society of Human Resource Management, apparently.
There we go. Society of Human Resource Management. I just call it SHRM. So yeah, their website just has a plethora of resources that will help you to get started in drafting your own, either from a template or from outline or whatever is easiest for you. If you want outside help, there are generally 2 different types of professionals provide outside handbook writing services: HR professionals and legal professionals. The pricing tends to differ. If you go to an HR professional, they tend to be a little bit less money than attorneys. I've seen, ballpark range, I've seen anywhere from $500 to about $2,500 for HR professionals. For lawyers to do it, you'd probably start at about $1,500 and go up to about $3,500. So there is overlap, and my view is that in a perfect world, you want both somebody from HR and somebody from legal to review it. But I think that's a general sense of what you'd be expecting to pay if you were to go to an outside professional.
Okay, good. So I think that answers a few questions that we received. Okay, so please put any other questions in the chat. Make sure that you have all the resources that we put in the chat. So I put Company Counsel's website. I put our resource page. I'll put those in again, and the link to the survey. All right, so we have another question. How often should an employee manual be revised?
I think it should be reviewed once a year. Just because you review it doesn't necessarily mean that it needs to be revised.
Right.
But if you're reviewing it and you see the need for a change, then that's a good opportunity to make that update.
Okay, great. And then we have a question about earlier in your presentation about medical marijuana use. If it is medically necessary to use throughout the day, is there a way to get some sort of certification or testing that allows that person to do their job while using medical marijuana? I believe that is a summary of the question that was asked.
So it's a great question. So again, medical marijuana period is still not legal technically in Pennsylvania based on federal law. However, under state law, it can be recommended by physicians. I say recommended and not prescribed because because there's actually a difference. It doesn't have the same weight as an actual prescription. So having said that, there are, and I'm not a medical marijuana expert, but there are various ways to use medical marijuana to treat patients. Some of it's it can be inhaled. Some of it's topical. There are creams. So there are, and not every application involves getting high from THC. So I think the recommendation will be to work with your, once you get a physician's recommendation, work with your physician, and then work with the pharmacist at the dispensary to come up with a schedule and a regimen that doesn't interfere with your work responsibilities. Having said all that, I'm not aware of, well, if somebody were to come in high from marijuana and argued that it was necessary for them, it was medically necessary for them to be high while they were at work, I think they could be terminated for that, and it wouldn't be a violation of their, that would not be a violation of their rights. Because it's one thing to be treated, but it's another thing to be impaired.
Right. So I think that the answer is that there isn't really anything right now to kind of give you a card that says being under the influence while on the job is okay right now. I think the answer is that just doesn't exist, right?
Right. And that's true of other drugs as well. I mean, there are other prescribed drugs that that impair the judgment of the people who take them. And even though it's legal for them to take those pharmaceuticals, they still can't be impaired on the job.
Okay, there's a question about free legal resources to help start a business. So we have a legal clinic at our office, and if it's just a matter of legal formation, where you're just looking to form an LLC or something like that, our consultants can actually help you with that. So you would just sign up on our website as a new client, and that's something that our consultants can walk you through if it's not the fall or spring semester, which is when we have our legal clinic. And our legal clinic handles pretty simple matters: legal formation, contract review. We do not do any litigation or trademarking. That's something that you would want to consult with a company like Bernard's office. These are student workers, so they're just handling smaller projects. question about the PowerPoint, and I think the answer is we will be able to send that out in some form, right, Bernard?
Yeah, absolutely.
Okay. All right. Excellent. Is there another question? No, I think we answered all the questions. So I think since we are almost at 1:20, I think we'll close out for this afternoon. Thank you so much, Bernard. That was a really, really excellent presentation. So timely, so much good information, and very understandable. So I appreciate that so much. And I know we're getting a lot of good feedback already in the chat from our attendees, so they really appreciate your time. Thank you to everyone for joining us. Please do fill out that very brief survey that I put in the chat box, and we'll include that in the follow-up as well. Hopefully everyone is inspired to either start working or updating their employee manual. So enjoy the rest of your day, and we hope to connect with you at the SPDC.
Thank you. Thanks, Jamie.
So much, Bernard.